Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. I'm a certified legal specialist in California workers' compensation, and I'm a trial attorney. I wanted to take a few minutes to discuss a very common problem in California workers' compensation. In California workers' compensation, an injured worker may be entitled to total temporary disability, which is 2/3 of their salary. A very common thing in workers' comp is that there are two scenarios, but both scenarios lead to a potential temporary disability overpayment. A very common issue in workers' comp is when the defendant stops paying temporary disability and asserts a temporary disability overpayment. That is essentially the work comp insurance carrier believes that they overpaid the injured worker. I can tell you that very often, if not the majority of the time, the insurance company is simply wrong and the injured worker is actually entitled to additional compensation and the defendant carrier is not entitled to an overpayment. So let's break this down. There's essentially two scenarios that this occurs. And before I do those scenarios, let me lay a little bit of foundation. An injured worker is entitled to total temporary disability, which is 2/3 of their salary, if a doctor is certifying that they're totally temporary disabled and cannot work, or the doctor is providing temporary work restrictions and the employer is unable to accommodate those work restrictions. In that case, the insurance company would be providing 2/3 of the salary while they're off. Now, the two scenarios in overpayment occurs are as follows. The injured worker is treating with their primary treating physician, and this doctor is certifying that they're totally temporary disabled or is providing temporary work restrictions and the employer is not accommodating. Thus, they're legally entitled to total temporary disability. And then they see a neutral doctor. Now, this neutral doctor, scenario one, says, this injured worker has reached their maximum medical improvement. They are what's called permanent and stationary. And this doctor says they actually reached their point of maximum medical improvement 6 months ago, 1 year ago, 2 months ago. Ultimately, when a neutral doctor is indicating that they reached their point of maximum medical improvement retroactively, the carrier is going to say, wait a minute, let's say this doctor says 6 months before. The carrier is going to stop paying temporary disability, and they're going to say, we overpaid you because we paid you the last 6 months. This happens a lot, and I see carriers asserting this temporary disability overpayment, but they're simply wrong in asserting this. Now, the seminal case that's on point is a case called J.C. Penney. That case basically says the doctor who is contemporaneously evaluating the injured worker and issuing contemporaneous opinion as to whether they have temporary work restrictions or total temporary disabled, that's the doctor who we should really be listening to. And unless the carrier objects to each and every one of those temporary disability findings and defers that to the neutral doctor, then essentially the primary treating physician should control, because that neutral doctor that you see, a year later or 6 months later, who's issuing this artificial PNS or MMI date retroactively, that's inherently speculative, because the person who's best fit to make this opinion is the primary treating physician who's seeing the person contemporaneously. So that case is J.C. Penney. So in that scenario, if a neutral doctor is issuing an MMI date, once again, maximum medical improvement, and saying that they're permanent and stationary retroactively, I fight that very vigorously, and ultimately the defendant cannot take credit for this without a petition, and the court ultimately has jurisdiction and is very user-friendly to the injured worker, at least when it comes to that aspect. Okay. So once again, to summarize, hypothetical one is that the injured worker is treating with a doctor who's finding that they're entitled to temporary disability. They see a neutral doctor. That neutral doctor says that they've reached maximum medical improvement previously, in this example, 6 months previously, and the insurance carrier requests repayment of that 6-month window. And the truth is, based on that scenario, I don't think they're legally entitled to it. And as that injured worker's attorney, I would fight to the death to make sure that there was no temporary disability overpayment or credit issue there. Scenario two is as follows. The injured worker is treating with their physician. That physician is indicating that they're entitled to temporary disability benefits. they see a neutral doctor, and that neutral doctor says, you know what, today they're at their point of maximum medical improvement, and issues a report saying that. Now, what will happen is that doctor will generate a report, and it'll take 2 or 3 weeks to issue that report and get to the carrier, and the carrier will say, oh, wait a minute, we've already been paying them for those last 3 weeks, and they're immediately going to stop. There's going to be a small credit potentially where they're indicating that the point that doctor found them to reach maximum medical improvement versus the date when they've got that opinion and stopped paying temporary disability, they're going to assert a credit there. But then they're going to stop paying temporary disability and potentially start paying what's called permanent disability advancements. Now, at this point, the injured worker is left where the carrier has stopped paying them temporary disability, but yet their primary treating physician is still certifying that they're totally temporary disabled, or once again has temporary work restrictions the employer is not accommodating. Now, when this happens, that person may then be able to go to EDD or state disability and collect the difference between what they're receiving from the insurance company and the 2/3 of their salary via EDD benefits or state disability. Now, flash forward to the time of settlement on this case. State disability or EDD is going to want all their money back, and they're going to file a lien on that case, and they're going to want all their money back. So at the time of settlement, the insurance carrier is going to say, well, there's a temporary disability overpayment of 2 to 3 weeks that we want our money back, and EDD is here and they want all their money back, and we're not paying that. That's going to come out of the client's settlement. Now, this is a bit more complicated, but actually there's some great case law, and I have rarely seen injured workers or their attorneys advocating properly for this, because I don't think there should ever really be a temporary disability overpayment or credit. And if you're an injured worker and you're listening to this and an insurance company is asking for some of their money back, they're probably not entitled to it. In fact, you may be entitled to even additional compensation. Now, under that scenario where a doctor has indicated, the neutral doctor has indicated that they've reached their point of maximum medical improvement, but the treating physician still certifies them on temporary disability, here's the analysis. There's a case called Forrest. Both the J.C. Penney case and the Forrest case that I've discussed, I also have other videos, and you should watch those videos specifically breaking down those cases. But the Forrest case says an injured worker doesn't reach maximum medical improvement until they've exhausted all reasonable medical treatment. So, I was in court last week on this exact fact pattern I see time and time again. Client saw the neutral doctor. The neutral doctor said he's at his point of maximum medical improvement. And we'll say that that was issued January 1st, and that the treating physician still certified them for another 6 months. Ultimately, the analysis is as follows. Which doctor got it right? Was it the neutral doctor who said that they've reached their MMI status, or was it the treating physician who says no, they weren't at their maximum medical improvement and they're entitled to temporary disability longer? Here's how you do the analysis. The Forrest decision says you're only properly at maximum medical improvement or permanent and stationary when you've exhausted all reasonable medical treatment. So when there's a dispute between the treating physician and the panel qualified medical examiner, the analysis is easy. You look to see whether there was contemporaneous treatment ongoing after the date that neutral doctor said they reached their maximum medical improvement. And in the case I was just on, my client had multiple injections and had physical therapy, and his condition changed with those injections and that physical therapy. Therefore, if I go to trial, that neutral doctor who saw them previously, who didn't know about the subsequent injections and the subsequent physical therapy and the change in their condition, that report, not substantial medical evidence, because it's relying on old facts and not taking in that germane or relevant subsequent treatment. So if I go to trial, that report is not substantial medical evidence, and that doctor's opinion as to when they reach their point of maximum medical improvement, that gets thrown out. And guess what I have left? The treating physician who found a longer period of temporary disability. So as long as the treating physician report is substantial medical evidence, the injured worker wins. No temporary disability overpayment. In fact, they're underpaid and entitled to a substantial additional amount in temporary disability, or if they've got that money from state disability, The insurance carrier has to resolve that state disability lien, and it does not come from the injured worker. So, if you're watching this video and you're an injured worker and you hear the phrase temporary disability overpayment or credit, hell, if you ever hear the phrase overpayment or credit, don't take the insurance company's word for it. Don't take what you're being told. Even if you're represented by attorney, if they're allowing that credit, I would question that credit. If you have any questions, feel free to call. My office has the answers and we're standing by. Thank you.